All right. Good afternoon, everyone. Welcome. As most of you know, if not all of you know, my name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice. And we are here as part of a monthly meeting for those involved in post-conviction litigation and investigations, where we meet once a month to have trainings or discussions or to cover issues that are really across the board, whether you're a prosecutor or defense counsel. Before we go further, I'm going to ask everybody to please mute yourself if you haven't already done so that the audio is a little clearer for us. So we are doing this because of a grant that we received from the Bureau of Justice Administration. Give me 1 second if you don't mind. Here we go. Okay. Where the Quattrone Center is a provider of technical and training assistance to grantees under the Upholding the Rule of Law grant and the Wrongful Conviction Program, as well as just an outreach center for those who are engaged in conviction integrity work from prosecutors or innocence organizations. We provide direct consultation and direct work with folks all around the country who are trying to do this kind of work. So today I am just beyond thrilled to have with us a gentleman who has just so much to offer for everyone. I got to tell you, Kenneth, every time I talk to you, I just learn more. So I'm just so grateful for your time. But for those of you who don't recognize the gentleman on the screen, this is Kenneth Nixon. Mr. Nixon was exonerated last year with the help of the Cooley Innocence program at Cooley Law School and, of course, the Wayne County Conviction Integrity Unit, led by Val Newman, who's probably on here somewhere. So Mr. Nixon has done just extraordinary work since his release. He has founded an organization called the National Organization of Exonerees. And the organization has been all around the country in their yellow t-shirts to help raise awareness about issues related to wrongful convictions, but very importantly, to bring the voice of exonerees and those who've suffered through this tragedy into the discussion of the criminal legal system, and particularly for criminal legal system reform. And I've asked him to come talk with us today, particularly because of that passion of his. So most of us have been involved in this kind of litigation and this kind of work for a while, but I really wonder how many of us have ever thought about how deeply we involve the people who are applying for help or that we're working with in the strategic discussions themselves. And so asking Mr. Nixon to really kind of share with us what he thinks that those of us who are doing this work need to know, what prosecutors need to know from the perspective of somebody who's been incarcerated wrongly and exonerated, what defense lawyers need to know about working with people who are in these discussions, because so many of the times we don't listen or we don't hear the voices of the people that we're working with, and to understand that they do have a role and they have an important role in helping to work for their own exoneration, but also to inform the criminal legal system and where it's going. So if you bear with me, I've got a couple things. One, I want to launch a poll so that we just get a sense of who's on the call here, so to help Mr. Nixon kind of understand. If you could just let us know, are you working as a prosecutor in the CIU or CIU? Are you working as a prosecutor in the office without a CIU, defense counsel, or are you just here to kind of learn something? While you're completing that poll, I'm going to share a quick video that Mr. Nixon did for Wrongful Conviction Day last year, if I can find it on my desktop. And just give me 1 second. Here it is. Nope. Where'd it go? There it is. Okay. It's a very short, about 2-minute video, I think, and we're going to share that, and then I'll introduce Mr. Nixon again.
One thing that hurt me to my core being incarcerated was seeing injustice, myself included. I took on this task of being a voice because I knew it needed to be somebody. Since being exonerated, I am now the chairman of the National Organization of Exonerees. Right now, in this very moment, we are in Kansas City, Missouri, advocating on behalf of Kevin Strickland and Lamar Johnson. In the short 6 months that I've been home, I've taken on advocacy, I've taken on reentry resources, I've spoken out on behalf of policy change. I've spoken out on behalf of accountability. I plan to be able to put myself and other exonerees in a position that we can further this voice. Nobody can tell our stories the way that we can. Nobody knows what it's like to be locked in a cage except those that have been there. The people closest to the problem are the people closest to the solution. This means something.
Okay, and thank you. I don't know, Kenneth, if you're able to see the poll, but it looks like over half of the folks who are with us are a prosecutor in a CRU or CRU, and about 25%, a quarter of the people are innocence or defense counsel. So leaning on the prosecutor side, if that helps. So I'm going to turn it over to Kenneth in just a moment, but I want to say that Kenneth is prepared to kind of talk with us for a little bit, but most importantly, he's very anxious to answer questions or respond to comments that folks may have. So you can use the chat, you can raise your hand using the little reactions button at the bottom of your screen, or if you're feeling particularly brave, go ahead and unmute to ask a question directly when we get to that. So thank you everybody for being here. Kenneth, thank you for being here. We're so, so grateful to have you and have you with us.
So my name is Kenneth Nixon. I was exonerated February 18th of 2021. I've been home for just over a year now. And sort of unintentionally, there was a group already in the process of forming when I came home. The exonerees in the state of Michigan were in the process of coming together, banding together as a group, as an organization. And at some point, I was voted to be the chairman of that group. And since being voted by my peers as chairman, we've sort of navigated quite a few issues that were huge issues when I came home. And I can confidently say they are no longer huge issues. When I say re-entry, I mean, we've tackled everything from vital documents to setting up bank accounts. We're in the process of doing our best to address housing, IDs. These are things that were huge, huge issues when I came home. It took me 3 months to get a state ID. It took me 8 weeks to get a social security card. It took me almost getting kicked out of the city county building to get a birth certificate. These are things that were problems that I didn't create myself. I believe that I asked some very high-ranking people some very direct questions that nobody could answer. And as a result of those questions being asked, the process was simplified hugely. I didn't lose my ID. You took it from me when you arrested me. So why didn't you give it back to me when you let me go? As far as my incarceration, I spent 15 years and 9 months incarcerated for a crime that I didn't commit. It took me close to 10 years to finally start to get people to listen to me. One of the messages that I want to deliver, and it's extremely enlightening that, Marissa, you did that poll because a lot of you work in a prosecutor's office. And the most difficult thing it took for me was to get somebody to hear you. The people that were supposed to protect me were the people that weren't listening to me. The people that were supposed to make sure that I was safe were the people that were victimizing me, to no fault of my own. And I was screaming about my innocence for years. When people finally began to listen to me, that's when things began to change. And I credit a lot of that to the staff at Cooley Innocence Project. Some of them which are on this call, and they listened to me. And that's all it took, was that initial conversation of hearing me. And it sparked someone to actually look into the issues that I had been complaining about. And that's how it began. To the importance of communication for the attorney-client relationship is beyond, I think it goes beyond recognition. A lot of people don't value how important that is. And for me, it was hugely important. The level of communication that I had with my attorneys at Cooley Innocence Project helped keep my stress levels down. It helped me control my anxiety. It helped me to function under all the stress of the investigation and navigating the conviction integrity process. That's an extremely stressful situation. I don't know how it operates in other states, but in Michigan, our conviction integrity unit operates in mostly silence. You know when it's your turn, when they tell you it's your turn, but beyond that, you know nothing. But the level of stress that comes with knowing that you're under active investigation, your case is under active investigation, when you add that on top of a highly volatile and violent environment where you're always on your P's and Q's at all times, the added stress of knowing that at any moment today could be your day it's unbearable sometimes. I 100% credit the level of communication that I got from my attorneys that kept me focused and kept me guided through that process. We had scheduled phone calls every couple of weeks. Even when there was nothing to report back to me about, she still took my call. She still said, "Hey, there's nothing to report, but I wanted to take the call and let you know, let you hear it from me. There's nothing to report." There was very seldomly that I talked to a secretary or a student that relayed that message. It was always directly from my attorney. That was hugely important, hugely important. And I say it was important, and I speak from personal experience because I was also in facilities where other guys were being investigated or handled by other innocence organizations, and they weren't getting that same level of communication from their attorneys. And I could personally see the anguish and the heartache that the non-communication was causing those individuals. And I was grateful that I didn't have to experience that. I was grateful that I didn't have to go through, days, months, sometimes years of wondering what was happening. The people that were helping me were not only helping me legally, they were helping me emotionally and mentally without even knowing they were. And that was huge. It was huge that that was available to me. That's not the case in every situation. And I know it. I've seen it up close. I've seen the guys have mental breaks because they haven't heard anything in 2 years, 3 years. Their attorneys aren't communicating with them. They're writing letters to the conviction integrity unit for months to no avail, not a response, not an acknowledgement, not an anything. I saw that up close. And, that causes people to doubt the process. That causes people to question the integrity of what's actually happening. And I know a lot of you have dealt with angry clients or bitter clients. You take on whatever trauma was caused by previous attorneys, the mistrust, but the non-communication only exasperates those issues. Not acknowledging only makes it worse. Yeah, I get it. Not everybody is easy to deal with. Not every client is easy to communicate with or to understand. However, an acknowledgement from time to time brings a lot of that down. It allows the person to know that you are really on their side. And that's all that we want most of the time. I just want to know that we're on the same team. I want to know that my loss is your loss. I want to know that my win is your win. And you don't always get that when your attorneys aren't communicating with you. Communication is a huge, huge thing when it comes to the work that we do. As far as I'm concerned, everybody on this call, we're pretty much on the same team. We're all fighting for the same thing from different angles. We're all fighting for the same cause from different ends of the spectrum. And, I know that in some of your job descriptions, some of your positions, you're not allowed to speak directly to certain clients. However, those of you that are, I think it's hugely important that you try to nurture those relationships, because at the end of the day, I think for me personally, these weren't just legal relationships that I built with these people. These people became friends. We were fighting for the same cause for years. You know, this wasn't just a one-off. I, I, I mean, we all know there's not a lot of exonerations that happen every year, but the ones that do, we often spend years trying to get to that place. So I think it's important to remember that your client isn't just a case file. Your client isn't just a stack of paper or binders in your office. There's an actual human being associated with those papers. It's not just case file, whatever number. You know, there's an actual human being attached to that. And there's real true emotions that are associated with that stack of papers. And somebody's on the receiving end of whatever plays out. I think it's really important for attorneys to remember that your client is a human being. To the people that have the luxury of reviewing these cases and the difficulty that comes along with reviewing these cases is unmeasurable. I mean, I don't know. I was on the receiving end of it. I wasn't on the giving end of it. But that being said, you have a difficult job. But try not to make it difficult for the other person.
So that, especially that last part, Kenneth, hit me, personally, and I appreciate you saying that. And I'm going to just encourage people to please use the chat, unmute, or poke a hand up to ask a question or have a comment and come in. And I know, Ken, that you understand the volume that the folks who work in a COU or innocence organization are dealing with. And I hear what you're saying about the communication. What advice would you have for folks, or what do you want them to know about kind of sending form letters or other, kind of ticklers of communication? Is that helpful? Is that not helpful? Are there ways to word that, to kind of go along the ways of trying to be more frequently in communication?
I guess it would depend on each case. I guess you can say the initial processes. I know from what I've seen here in Michigan, it's typically, if you have a lawyer, the response is, all our communications go through your attorney, which is a fair response. I would expect nothing less from, an integrity unit or prosecutor's office. If you have an attorney, I shouldn't be talking to you directly. That's just, an ethical responsibility, but at least acknowledge that you got the letter. I don't want to be mailing the letter to the middle of nowhere half the time and not getting the response back either. There's an importance there too, though, that, maybe there's a mistrust with the attorney. Sometimes it's necessary to acknowledge whatever it is that's going on and ask questions, what's going on. But as far as the form letter, I think it should stay consistent. As long as your letters stay consistent and it's not wavering, it's not changing, then I think that's perfectly fine. But for those situations where you're not dealing directly with an attorney, what I've seen is, less is more. The less you say, the better it is, but at least acknowledge to the person that you've received whatever it is. Yes, you're in the pipeline or your name is on the list. A lot of times that's all the person wants to hear anyway. Yeah, they're going to get to me eventually.
Right. And there's a question in the chat from the prosecutors asking that very question. So if the prosecutor just lets you know your file is in the process of review, but that not yet complete, is that enough? Or should there be more detail that's coming back to you?
I think knowing what I know, I think that would be enough, because if you open the door to say anything more than that, you're going to open the door for a ton of questions that you're probably not prepared to answer most of the time. Does it cause frustration on the other end? Yes. However, you protect yourself from 1,000 more questions that you're not ready to answer. So, again, I've seen it up close where, the response is typically you're on the list and where your name comes up, we'll get to you. That's a pretty firm answer that nobody can argue with. You acknowledge that, yeah, we've got you on the list, but I'm not telling you anything until your name comes up.
And I think related to that is this issue of managing expectations. for people, right? I think like a lot of the defense lawyers on the call will kind of feel that when working with the client, you want to manage the expectations. You don't want to overhype. You don't want to put on too much hope, but you also don't want to be kind of, the Debbie Downer and, this is going to take long. But what's the balance there with working with a lawyer and an applicant, particularly in this situation, of trying to help meet that balance of meeting expectations, keeping hope, but without thinking I'm getting out tomorrow or the next day or even the next week?
For the people associated with the Innocence Project, I don't think you realize how much power you represent, right? A visit from an Innocence Project is hope all by itself. I don't care what you tell me at the end of this meeting. The fact that you showed up tells me I've got an issue there, because you would have never came to see me if you didn't think I had an issue. So the fact that you came to see me represents hope. Now, the other side of that is I want to know that you believe in me just as much as I do, right? I don't want you coming to tell me that we've got a 15% chance at winning this. Like, that's, to me, I mean, you just killed the hope when that you showed up with. But the thing is, when honesty is the most important thing. Tell it straight like it is, no false hope. And I think, and for me and the people that I've known that's gone through the process, honesty is what kept us focused. Give it to me straight. Tell me exactly what you think. Tell me exactly what you feel, and let me decide how I feel about it afterwards. But don't tell me something that you know may or may not be true, or you're hoping that eventually we get to that place. If we've got a rare chance, 1 out of 100, say that. Let me decide what to do with that information. But don't try to convince me that we've got a really good shot at something that in the back of your head, this is a long shot. Honesty is the most important thing.
And I think on that note, also I think the traditional defense lawyer, like, you know, image is the defense lawyer kind of in saying, I know what to do, I've got this, and not really involving the client much in the strategy or in how things will play out. And I don't know whether, like, my understanding of my discussions with you is that was not the way it was with Cooley, that they were very much engaging you in the process of understanding, getting your input, your thought, in terms of strategy. How do you recommend lawyers avoid that kind of, like, I'm the knight on the horse mentality, but really more listening and encouraging more cooperative relationships with their clients, particularly in something that's so difficult as post-conviction litigation?
I think my situation was unique itself, but I think you have to gauge that on a case-by-case basis. And what I mean by that is, for every innocence lawyer, you're inheriting trust issues from whoever came before you. You have no control over what happened before you. You have no say-so, and your responsibility is to rebuild that trust and convince this person that you're the right person for the job. Everybody, I think what a lot of people don't realize is, as hopeful as your presence is, you're still auditioning, right? A lot of what we deal with on a regular basis is mental health issues that are exacerbated. However, some of us are better off than others. The way that we operate and the way that we process things is different. Each individual is different. You're not going to have two clients that are the same. You're not going to have, every situation isn't going to be a Kenneth Nixon where you can come and talk to me and I'm going to understand what it is you're saying to me. Legal jargon doesn't help a person with an 8th grade education. That law book that you just read before you walked into that meeting is going to do nothing to a person with no education whatsoever. He's not going to understand anything that you just said to him. So I think it's important to always walk into the meeting with an understanding or an open mind to what you're about to walk into. You just don't know. But for those situations where you're attempting to manage the expectation, truth, and use it as many layman terms as you possibly can. For me, you are correct, Marissa. This was a different process for me. My attorneys engaged me. They asked me questions. we were a team. It wasn't my team was working, for me. We were the team. When they had questions, they asked me what happened in this situation. As we all figured out by now, everything isn't always in the transcripts. We don't have every sheet of paper that's associated with the case every single time. So to their credit, they just asked. They just asked what happened in this situation. We read something or there's a piece missing from this document. The second page of this statement is missing. Do you remember what happened? This page of the transcripts is missing. Do you remember what this person said? And as a team, we were able to work through a lot of those issues and get us to the next level because we were working together. The communication was open where, that question, if I had the answer, I did. If I didn't, I don't know, and we were very clear with each other as our relationship grew as we navigated the process. If I didn't know, say you don't know. If as the attorney, if you don't know, say you don't know. There's no point in telling me something that later on turns out to be wrong. Just tell me you don't know. I'd respect you better if you told me I don't know then, because in prison, if you tell me something that later on changes, it's interpreted as you lied to me. It's interpreted as you gave me a false truth. You sold me a hope that you knew eventually could be wrong, instead of just saying, I don't know. And in my prior experience prior to Cooley, I dealt with that repeatedly, where you have arrogant attorneys, egotistical attorneys that feel like they know everything. I know how it's going to play out. I can tell you this is what's going to happen, and then it doesn't. Right? Throughout the appellate process in Michigan, attorneys tell you all the time, we'll get it when we get to the feds. We'll get it when we get to the feds. And so often you get denied, and now you're looking at your attorney like, yo, what happened? This isn't what you told me. This isn't what I was expecting. Instead of just saying, I don't know, you told me something that couldn't possibly have been 100% true. So and what happens later on when you get an innocence organization involved is that level of mistrust is now in your lap.
So they're kind of having to, like, not fix, but account for at least the acknowledgement of. So maybe one question is, how was your relation with your prior attorneys? And was it good? Was it maybe having that information? Would you recommend that that's something that innocence lawyers in particular should know about?
Absolutely. In fact, I think that should probably be a question on the application. Who was your previous attorneys? Because a lot of us, I mean, as we all know, this work is a very small network of people. Some of you that have been around for a while, some of these attorneys. You also know their personalities and their histories and, some of the things that they've been involved in. So sometimes just knowing the name of who touched the case before you could give you some insight on how to handle the client.
Right. There's a couple questions in the chat. I want to shift back to working with prosecutors. Now, I think you mentioned before that you didn't really did you have direct contact with the Wayne County CIO, or was it all through your attorneys with Cooley?
No, it was all through my attorneys up until the very end when it was pretty much time to go. All my communication went directly through my attorneys.
Okay. And from other people that you've worked with, if they've had relations directly with CIUs, is there any particular feedback you can give to the prosecutors here of their communications with applicants and convicted individuals? Like, they have a different role. Obviously, it may not be as kind of cooperative as yours was with Cooley or as an attorney with Cooley, but what kind of advice or suggestions would you have for the prosecutors on the call in terms of communicating with people who are in prison or who have written to them for help?
My advice would be stay consistent. Stay consistent as possible. I think you have a sense of this, but you may not know it directly. And I'll tell you, directly. We compare notes, right? We compare your letter to the letter that you sent the guy across the bunk for me. We compare everything. So if my letter is different from his letter, I want to know what happened. What did he say? How did you get a different response? But in my experience dealing with the conviction integrity unit here in Wayne County, they've been extremely consistent. And also the statewide conviction integrity unit here in Michigan from the Attorney General's office, they've been extremely consistent, and that helps because it doesn't leave room for misinterpretation, right? Every word is consistently the same unless there's a reason to deviate. But the consistency is what helps keep the emotional part of it under control. As long as you keep telling me the same thing, I don't have a reason to believe anything different. But the moment you tell me something different, it's going to open up a field of questions for me.
So consistent, more frequent, it sounds like, is your basic advice for CAUs in particular, right?
Yes, yes.
There's another question in the chat. I'm not sure if this is also from a prosecutor's perspective. Any advice for prosecutors who are speaking with family members of the convicted individual that have reached out to the unit? Is it the same rule? Is it that kind of that you're talking about? Or are there other ways that prosecutors should be working with family members, or should it just be nope, hands off, it's all got to come through the person who wrote to us?
I'm new to the work, and I've been at it, just over a year now. And my experience has been to make sure that you ask the right questions. That typically kind of weeds out who you should be talking to and who you shouldn't be talking to. Not asking the right question could have you walking down a dark path for a long time. But in my experience, very direct, and listen to what the person is saying, and don't judge, just listen, because most of the time they're going to tell you what it is you're looking for. And I've consistently had to navigate the process of the difference between actual innocence and technical innocence. Family members don't typically know the law. They typically assume, this is somebody that I love, so they have to be telling me the truth. But they don't know the difference between manslaughter and first-degree murder. They don't understand the difference between, a heat of passion crime and he was in Florida at the time it happened. They don't understand that. They think innocence is innocence, and that's, as we all know, it's not the truth. That's not how it works in the court system. So asking the right questions can get you to those places, though. And I've consistently rejected dealing with a lot of cases once you start asking the right questions. And for me, I know it may be a little bit harder for lawyers in your position, but the best advice that I can give you is ask the right questions. And again, each person is different. Each family member is going to be different. You have to kind of navigate the emotional side of it sometimes when you're talking to people. However, asking the right question and asking it the right way, where it's understandable by the person that you're talking to, could be hugely effective in deciding whether or not this is something you want to continue further with.
So, and along those lines, one of the kind of, I guess, assumptions people make is that in prison, people talk about their cases in a way that's very different from what a CIU or innocence organization needs to evaluate to be able to see if it's a case that they can review, because the CIU and innocence organization is all about the facts, about who said what, and was it an eyewitness, was it a potential false confession, not so much about the procedural errors or constitutional violations, which can feel very personal, I'm sure, to the person who's been convicted, obviously. But any advice in terms of how to navigate toward and help people understand that the way the lawyers need to hear about the case is a little different than what may have preceded, if that makes sense.
Absolutely. And as you said that, there's a specific individual that I remember repeatedly having this conversation with while I was inside. And he was communicating with an innocence organization. And his argument was always the same. This person said this person said that, this happened. So the way I was able to boil it down to him and really get him to understand was, what evidence do you have that proves you didn't do it? That's the only thing this organization cares about. What can we use to show that you didn't do it? If you subtract all of the testimony from the case, what do you have that says you didn't do it? Because if you can't bring that to the table, you're in a tough position. At the end of the day, and that conversation went on for weeks. His argument went from prosecutor misconduct to ineffective assistance of counsel. And I repeatedly had to explain to him, That has nothing to do with your innocence. Procedural errors are different from actual innocence. What can you show that says you didn't do it? Can you show a timeline where you were? Can you show, what you were doing at that particular time? But being able to get the person to understand that there's a difference is extremely difficult. I know that for sure. My advice in that situation would be to just simply ask the question, what do you have that can show you didn't do it?
And if the answer there is no or nothing, where does the conversation go from there?
Problem. I mean, we've seen those guys. We've all seen those cases where try as you might, we just don't have anything that supports his claim or her claim. Those are difficult situations to be in. I mean, I've tried my best to guide people through that process itself, but when you don't have anything to work with, you just don't have anything to work with.
And how would you advise lawyers or prosecutors who are trying to convey that message? I believe in you, I believe in your innocence, but there's nothing I can do. That is an incredibly hard conversation to have. Is there any advice you can give to folks who are facing that kind of situation?
I think the beginning stages of that conversation is being clear up front. No rock goes unturned. I will not stop at anything to explore every avenue possible. But if I've exhausted my list of possibilities and there's nothing there, then I don't know what else to do. Maybe this isn't the case for me. Maybe it's something that a fresh set of eyes needs to look at. But I mean, I think from the other side of this conversation, we all expect that at some point anyway. At some point, by the time an innocence organization or conviction integrity unit gets involved, you've already pretty much exhausted all of your appeals. You've gone through 3 or 4 attorneys, sometimes more. So the disappointment isn't unusual. However, we'll respect the fact that you tried more than everybody that came before you. At least rest easy. At least I'll rest easy knowing you tried everything you possibly could. But, a lot of people, that's hard. It's a hard conversation to have when you believe in that person. But again, honesty is the most important thing. Say that.
And then having contact with those people ongoing, or call me if something changes. Like, how do you end that part of the discussion?
I mean, I guess that would be up to the attorney at the time dealing with it. If this is someone you think you can continue to deal with as you go forward, then, treat the relationship as such. But if this is someone that could possibly be, mentally unstable or, cause you your own stress that, you just can't deal with, then you have to handle it accordingly. Everybody's, again, not the same. Some people are going to take that news differently. But I think in my experience being on the inside, dealing with most people that I think to be in this situation, we were all pretty understanding. Does it hurt? Absolutely. Does it sting? For sure. But I'd respect you being more honest and upfront than I would for you, to tell me we're just going to keep looking, only to find out 5 years from now you set the case, under your desk somewhere and never looked at it again.
And I feel terrible for not doing this before, but of course Kia Hayes is on the call with us as well. Kia works with us here at the Quattrone Center, also with CIUs around the country. And I think, Kia, I apologize for monopolizing Ken's time, but I don't know if there were questions you wanted to bring in as well. But there's one more question in the chat that I wanted to bring up, which was shifting a little bit focus of areas of wrongful conviction or topics related where we need more research, where we should be looking at things from a different perspective or with more information and data. What do you think?
I agree. I agree 100%. There are still some avenues that are left unexplored. I think when I talked about it, if for you, those of you that don't know me, I am currently a college student, and I've had the opportunity. I have the current opportunity of doing a research paper, and I've chosen the topic of, do wrongful convictions affect low-income communities more than affluent areas? This is an area that I don't think has been explored. to my knowledge, I haven't discovered any research that's been done on it. However, the research that has been done highlights an issue that we already know to be true. It's just not openly spoken about. But this is something that I think is important. Why? Why is this happening? What's different in your zip code than it is in mine? You know, why is this so concentrated in certain areas and certain communities of our country? As we all know, yes, this is a nationwide problem. This is, you know, this isn't a Detroit problem. This isn't a Philadelphia problem. This is a nationwide problem. But how come there's one wrongful conviction in one part of the state and there's 40 in another part of the state?
Mhm. And there just a question just came in from the chat. What was the result of the conversations with the gentleman that was raising the procedural issues, where you kept asking him, what evidence do you have to show that you're actually innocent? Did anyone take his case, and whether or not you believe in his actual innocence or factual innocence?
Um, I think he's still going through the review process. I haven't checked in with him recently. Um, whether or not I believed in him, I'm probably the worst person to ask because I'm skeptical about everybody. You know, the process itself, going through the process itself frustrated the hell out of me. It really upset me to know that I was in the presence of people that I knew to be guilty, but were still trying to make it through the process themselves. And that frustrated me because I knew and understood that, you know, I sat there for possibly another 6 months, a year, or however long it took for them to figure out that this guy was guilty, while I sat there waiting my turn, having to navigate this, you know, emotionally stressful process while he knew he was going nowhere. And so I approached a lot. I'm a hard person to convince when it comes to innocence. So even in my work now, when we take on cases that have already been vetted from innocent organizations or conviction integrity units, because you guys have got the process. I've been home a year. I don't have the process. So I have to trust the resources that I have available to me at the time. And, you know, the one thing I can openly admit on this call is you guys have got the experience. Yes, I've lived it from the other side. I've seen it from the other side. So I have trust issues when it comes to this issue, but I can say that in my experience, there were a few people that I can say that to this day I'd attach my name to. Not many, not many at all. And 5 fingers on one hand is too many to say. So, and I spent a decade and a half incarcerated. You know, I came in contact with quite a few people during that time, and I don't trust them all. There was a question that, you know, everybody says they're innocent, everybody says they should be out of prison, and we had a running question that I would ask a lot of people. If you had to attach your name to one person and tag your freedom along with that person to never commit a crime again, pick them. Pick one person to cut loose right now and your freedom depended on it, who would you say? You had to trust that that person would never commit another crime for the rest of their days, and I don't know anybody that was able to do it.
Thanks so much, Ken. And I mean, you know, talking more about the people that were inside that you tried to guide and help to understand the process and what was needed, you know, to really get them out. Who did you turn to? You know, who guided you and who helped, you know, educate you, you know, about what you needed in your case, you know, or what the process was, or was it just kind of learning on your own, or your attorneys?
Um, my response to that question is kind of multi-tiered because it was a little bit of both. And what's crazy is, ironically, the people that helped me get free eventually help themselves get free. Some through the same avenues and channels, but I typically talk to like the older people that have been through the process. Strangely, a lot of the exonerees that I know here in Michigan, we actually met inside. We met, you know, in the law library, studying our cases and asking questions amongst each other. And, you know, we didn't know everything. We had no idea about some of the questions or how to answer some of the questions on the applications. We didn't know. So we had to rely on each other for information because we just didn't know. And the one thing that a lot of us could say was that we started to understand the process a little more, right? We didn't know what was happening behind the scenes, but we got pretty much the questionnaire part down pat. We knew exactly what they meant when they asked what was newly discovered evidence. We knew exactly what they meant when they said, we need your case number for, your habeas petition. We began to understand that on a different level. My attorneys, from Cooley, thankfully, Lori Montgomery, I think she's on this call. She helped me navigate a lot of that misunderstanding, right? What I didn't know, she explained. What she didn't know, she told me she didn't know, and we'd go research it together sometimes. We tried to figure out answers to stuff that we didn't know. So it was a little bit of both.
Yeah, and then, sorry, it looks like we have some questions, but I guess just talking more about sort of your process, your journey after you were wrongly arrested at 19. Sorry, if everyone could just mute themselves, we'd appreciate it. Hello? Okay. I guess just after you were, arrested, 19 years old, new father, how was your process in terms of getting help? I mean, how did you link up with Cooley, and then how long after you were in did you link up with Cooley, and then how did you then, you and Cooley link up with Wayne County?
So my process with Cooley is a bit interesting. I'd actually been told no from Cooley previously. And I actually just told the story not long ago. So I started writing letters the day that I went into the system. I sent, I don't know how many letters. I still have a stack of rejection letters to this day, in my folder back at my mom's house. And those were the people that were courteous enough to respond and tell me no. Just think about all the people that I wrote letters to and they didn't even have the courtesy to respond. So, that there was a lot of pain associated with that letter writing campaign that I was on. However, about at one point during my incarceration, I was on a waiting list for 4 different innocence organizations. This is against all the rules that were told to me, but I was leveraging what I had to try to get myself in a better position. They tell you not to contact multiple organizations. If you're on one waiting list, don't contact us. Let us know what they said. But after so many rejections letters, I had no choice but to leverage my own freedom. Cooley came about because I can't remember exactly the day, but my case involved a Molotov cocktail. The cocktail in my case was introduced into evidence at trial. I had no idea, what it was, what I was dealing with at that particular time. All I knew was that my attorneys, everybody that I'd spoken with for years had told me, DNA was impossible. There was no way there was DNA associated with it. One day I was watching Forensic Files, and there was a case on Forensic Files that someone tried to set a house on fire, and they did. I want to say it was DC at the time, Washington DC, but they did DNA on the rag that was recovered, and there was DNA found on it. So that started me down a path of trying to find other cases associated with this. At the time, I had a private investigator from Ohio that we'd retained. I went to the law library. I spent weeks, typing in keyword searches, trying to figure out if there were other cases that were similar to mine where there was DNA evidence. I located a case in New York from 2013 where they did DNA on a Molotov cocktail remains, and they identified a suspect because of it. I printed the case out. I immediately called my investigator. My investigator's response right from the very beginning was, "This is impossible. I've never heard of this happening." So I sent him the name of the case. He looked the case up, and he had no choice but to dig into it further. A week later, he sent me tons of information associated with his research. and I attached it all and I reapplied for Cooley. At that point, they couldn't deny me because I had evidence that DNA could be done. So I sort of leveraged what I'd figured out to try to force them not to tell me no again. That's how Cooley and I began down this journey of exploring my freedom.
And how long was that after you had been?
About 13 years in. I want to say about 13 years in is when all of this information started to come about.
Okay. And then walk us, like our internet is getting shaky.
So while Kia's checking her internet, because I'll say it, Penn's internet sucks today, there was a question in the chat that was asking about an application. Did you complete an application for the CIU, or was it, or something for a Cooley? What kind of, was there a questionnaire or an application that you had to complete at some point, either for one or the other or both?
Yes, for Cooley, there was an application process that I went through. The CIU does have an application process. I myself didn't personally fill out my application. My attorneys did. We agreed that they were in the best position to do it, to make sure that everything was covered and there were no mistakes made. So I let them.
Okay, and I don't know if you've seen CIU applications, but the question was really about, like, I think a lot of prosecutors are very concerned about how questions are worded. Yeah, can a questionnaire be too long? Can it be too short? Like, is there something that, I think there's a balance between prosecutors needing to get some information to be able to see whether it's a case that they can take forward versus getting too much information that you're kind of scaring somebody off, that they won't fill it out at all. I don't know if you've seen applications or seen kind of questionnaires from other places other than Cooley that you have an impression about, or if you have a thought about that.
I've actually seen multiple applications, conviction integrity units, different innocence organizations, media outlets. I've seen quite a few different questionnaires. I don't think it really makes a difference how long or how short it is. I think the University of Michigan's is like 19 pages. I think the one for Cooley is like 9. The conviction integrity units is 4 or 5 or something, and that may be more. But they range, and I don't think that ones that I've seen are pretty well worded. I think the problem that you potentially run into with the longer ones is what happens if you send an application to a guy that doesn't have a very high comprehension level. That's where you run into the problem, because now he has to rely on somebody else to translate the information for you. That's a difficult thing, but I don't know any better way to handle that situation either. The wording of the questions, in my experience, I think all the applications pretty much say the same thing. They just, some of them take the long way to get to the answer they're looking for, and some of them are very direct of, what you're looking for. I don't think there's a gift and a curse to the application process. There's no right or wrong way to do it. In my opinion, if the person wants his freedom bad enough, they're going to fill it out.
Yeah, I think that's what a lot of the gentlemen that I know who've been through the process say, exactly that it doesn't matter how long it is, I'm going to fill it out so that I can move forward with that. We just want to point out that we're getting toward the top of the hour, and Kenneth, we wanted to save a little additional time for you to kind of talk about the re-entry process and what you think prosecutors or defense lawyers need to know about that aspect of it. But once the exoneration has gone through, now what? And what role, if any, prosecutors have in helping exonerees re-enter society and kind of get on their feet, and certainly for the innocence lawyers or defense lawyers on the call, what that is. And just want to preface that by saying that at next month's meeting, we will be talking with prosecutors and innocence organizations that are doing that work and have been doing it for some time. And I think it's Baltimore, Wayne County, Arizona Justice Project, and a couple of others are going to be on that as a panel discussion, a little bit more in the details on it from the professional side. But to key that up, your thoughts on what is the role of the lawyers in helping somebody that they've exonerated come out and re-enter society?
I guess it would be the safe answer is it's a case by case situation. However, I understand, not everyone understands this. I understand that the lawyers' jobs, the conviction integrity unit's jobs, the innocence organization's job is to get you out. Anything that happens after that is because you're good people, right? Anything that happens beyond that part is because you're a good person. You are committing your time, your energy, your resources to this person on the outside because it's the right thing to do, not because of there's an obligation to do it. Some people misconstrue the two because they feel like you're responsible for them once it's over with. I get it. How do you explain that to a person that doesn't though? And for people in my situation, I think for a prosecutor, not long ago, I got a question from a prosecutor that it put me in a position to make sure that I informed every other prosecutor in this work of. The question was there anything that was more important than the other when I came home? Was there something that the prosecutor could provide that was extremely important that helped me into in my reintegration? The answer to that question was the court order. The court order from the judge that says you were exonerated was hands down the most important piece of paper that I received when I walked out of that jail. There was nothing more important. And the reason that it became important, because I don't know how it works in other states, but in Michigan, the conviction is still active until, the process is complete. There's a process that takes place, whether you're compensated or not. There's a process that has to go through. Once you're compensated, the judge orders that your record is expunged. For those that have not been compensated or the approval process has not taken place, that is still an active conviction on your record. Can you imagine having to repeatedly explain to employers or housing people why, when they ran a background check, this murder conviction came up? I dealt with that repeatedly, over and over and over again, that I had to explain why, when they ran my name, this murder conviction came up. And to no fault of my own, here I am. And I don't know if everybody realized this or not, but it's a form of re-victimization. I have to keep repeatedly explaining over and over and over again that I did nothing to the system. The system wronged me. Try explaining that to a cop on the side of the road that pulled you over for blowing a stop sign. He doesn't care about that. He can care less about that. All he knows is you're a convicted murderer riding around in his city and you blew a stop sign. That's a totally different conversation from somebody that with a valid license and, I turned when I shouldn't have. That conversation is totally different. Or I'll give you a personal conversation. And I told the story at Cooley not too long ago. My stepfather's got 20 plus years at Chrysler, the automobile company. He uses his reference to get me in. I get a call saying the background check came back. This is an active conviction. So I'm doing my best to explain to this guy that this is an error. It's wrong. His argument is when he runs a search, it comes up as an active conviction in 3 different databases. So I simply asked the guy, yeah, it also says that I'm doing life in prison. So what do you think happened, sir? You think I broke out of prison and applied for a job to work at your company? Is that what you think is going on right here? So naturally, he's like, all right, I'll call you back in a few days. So a couple of days later, I got, the approval, but the difficulty of having to repeatedly explain that. I was in a store when I had to explain that. I couldn't stop and say, call me back in 20 minutes. So I was in a store and now everybody's looking at me like, what the hell is this guy talking about? There's a level of difficulty that comes with having to constantly and consistently repeat that over and over again. But that court order from the judge allows me proof. It allows me to show I wasn't the one that screwed up here. It wasn't me. It wasn't my fault. That one single piece of paper changed a lot of conversations. And again, I don't know how it is in other places, but that was important. that was hugely important as I, made my way back into society.
Wow, I mean, that's amazing that you had that experience, and I know that for a lot of other exonerees, they have the exact same experience in trying to explain, what happened, every single time they're trying to move on and, this comes up and they have to explain over and over again. Um, were there other things also besides the court order? Were you also printing out, articles and things like that to show
Absolutely. I
people?
didn't have a choice but to, um, the articles become, in Michigan, it's gotten better. Since I came home, we've a lot of fuss about it because I wasn't the only one suffering from this issue. But um, having an ID, having a valid ID became huge. And I'll give you an example from personal experience that was a game changer for a lot of people in my circle, a lot of the lawyers, a lot of the people associated with Innocence work. Not long after me coming home, uh, a friend of mine bought a trip to Las Vegas for me. And at that particular time, I hadn't gotten my state ID yet. I still had the prison ID that was given to me, my discharge ID. I go through the process, we get on a plane, we get out to Las Vegas. They told me that I couldn't get in the adult swimming pool because my ID wasn't valid. It was not a valid state ID. So now my friends are arguing with the security guard about, what do you mean? This came from a legal state department in the state of Michigan. And her argument is it wasn't issued by the state itself. So again, me being a smart aleck, I asked a very straightforward question. So I can go through a national security checkpoint in an airport with this ID, but I can't get a suntan with this ID. Make that make sense. And again, I mean, she still rejected me. We didn't get anywhere with it, but the point was, it stung. It stung. Like, here I am in this situation in this long line of people, and we're arguing with a security guard over something that I have no control over. None whatsoever. I couldn't, there was nothing I could do besides tuck my tail and go lay down. Like, but that was something that was huge. It was very, very huge. And again, once a lot of the people in our innocence movement here in Michigan caught wind of the difficulty that this caused, they set out to solve the problem. And to their credit, a lot of people, Rob and Lori, a lot of people here in Michigan, Dana, this issue is no longer an issue. The guy comes home and he's got an ID within a few weeks of being home. It took me months to do, to solve a problem that shouldn't have been a problem to begin with.
Oh, that's so great. And thanks so much for shining a light, on that important issue that people don't realize, right? Until someone says, like, this is a problem. There's other people, besides me who are trying to deal with this. Is there anything else besides getting an ID, getting that court order that, are so important for reentry and for, trying to, rebuild your life that we might not have, that we don't even think about?
Uh, Definitely. Vital documents are huge. Vital documents are beyond huge. Uh, uh, it took me 6 weeks to get a Social Security card, and the Social Security office was walking distance from my home. The reason that the distance is important is because I ordered a watch from overseas and it was on my doorstep in 3 days. I couldn't get a piece of paper from a state agency that was walking distance from my home for a month and a half. I don't understand how this was the process. Why? How could something from a whole nother country be on my doorstep in 3 days? But here I am, trying to get myself back into society, and it takes a month and a half. That part was extremely difficult to deal with. Again, another process that we set out to fix, and I can say that we've made a lot of progress there. Bank accounts was also something that a lot of people don't realize. This is something that's hugely important. And it's important, especially for the guys that are associated with an innocence organization. Typically, innocence organizations have freedom funds or walking funds or some sort of fund where, they try to give the person money to help get them back on their feet. That money comes in the form of a check. Without a bank account or a state ID, you can't do anything with that check. I found myself sitting on cash or checks for weeks because I had no way to cash it. Um, the importance of a bank account can't be overstated. This was a problem that, again, we set out. And a lot of these issues, in my experience, right, lawyers typically deal with, the policy part of it. I just developed relationships with people that can help solve this problem. When when I came across this bank account issue, I spoke to a few high-ranking people. And next thing you know, I was introduced to the president of a bank. I explained the problem to the president of the bank, and he said that it would no longer be a problem. So far, in the months that I've dealt with him, this is no longer a problem. Our process is very simple. I call and say, hey, we've got a guy that was exonerated in Lansing. He says, where? I tell him where. He says, I'll call you back. He calls me back and tells me, go to this branch and ask for this person. They're waiting for you. Simple. We didn't have to change any policies. We didn't have to go through some giant ordeal of getting, something fixed. We just needed to talk to the right people. It's not always about policy changing or making an issue out of something. Sometimes it's just having a conversation with the right people.
Wow. Thank you so much. And our time is almost up. As we close out, I just wanted to give you another opportunity, if there's something that you haven't mentioned that's really important that you want prosecutors and defense attorneys to know. And then also, if you could just tell us a little bit about what your organization is up to, and how we can support it.
As far as the message to prosecutors and attorneys, I think everybody here is doing a great job. We are increasing the number of exonerations each year. The information sharing has been great. Technology has been wonderful, and helping to pass along information. I think the key is making sure that we're all staying communicative with each other and making sure that everybody stays consistent on the goal. Staying focused on what's important and not being sidetracked on the little things. It's, as we all know, things get lost in the details, but it's the avid fighter. It's the person that never lets go is the one that typically prevails. From my perspective, I think that everybody's work here complements each other. I think we're all doing an excellent job, and I appreciate each and every one of you, individually and collectively. Without the work that you guys do, there could be no me, right? There could be no organization of exonerees. This is something that is extremely, extremely important. From our group's perspective, I think we have a little wiggle room that some of you may or may not have, right? I can say what you can't say sometimes. I can compliment things that you technically can't sometimes. As far as the group goes, we are doing our best to travel the country and bring as much awareness as we possibly can about this issue. Sadly, there are still tons of people that don't know or don't respect this issue for what it is. But with good people, I think we're making some headway. We're making a lot of progress. We're bringing a lot of people to the table that typically wouldn't be at the table. I've had some really strange conversations with a lot of people that, maybe 5 or 10 years ago, they thought they got it right every single time. And they meet a person like me and you get a better perspective of you don't get it right every single time. At the end of the day, we're all humans. Humans make mistakes, but admit when you're wrong. Take it on the chin. Admit when you're wrong. We're humans. We don't get it right every single time. Sometimes it's best to just accept that this is one you couldn't win. Sometimes it's best to pass it on to the next person. Maybe they can see something you can't see. But, at the end of the day, know where you stand on it. Our group is doing our best to work collectively and bring some unity within the exoneree community. We're trying to control the narrative as much as possible. I don't know how effective we are at that sometimes, but we're doing our best to make sure that the messaging is proper and appropriate and that people understand what's happening. This shouldn't continue to be happening, and sadly it is sometimes.
Thank you so much again. It's been truly an honor and a pleasure to have you and have you share some of your experience and your wisdom and your insight with us. I guess how can folks get in touch with your organization to learn more about what y'all are doing?
Currently right now we're in the process of, getting websites built, and we are filed with the IRS. We're pending approval for nonprofit status. It's been a wonderful journey to navigate that process. We were individually, we all have social media pages. Myself, it's all of my social media pages is, Kenneth Nixon. I'm sure that you'll find some of the other guys there, Marvin Cotton, Kevin Harrington, some of the more visible guys that have been working just as hard as I have. We are in the process of getting social media platforms built, but as of right now, we don't have a specific landing page.
Okay, well, just keep us posted, and as soon as it's up, let us know, and we'll send it out.
Okay, thank you.
And I think everybody, is joining in on saying thank you so much for your time, Mr. Nixon. I see a lot of very excited folks on the call. There's a lot of thank yous in the chat for you to take a look at. And for everyone, thank you for being with us. These are monthly meetings. Our next one will be held in April, second Wednesday of the month at 2 p.m. As I said, there will be talking with prosecutors and defense lawyers who've taken on that responsibility, as Mr. Nixon talked about, of helping exonerees reenter society. So for that, thank you everybody for being here. If there are other topics you'd like covered, please reach out and let Kia and I know. We will put it together. But great to see everyone.